Today's SC judgment is based on vicarious or vicarious liability. It's one of the most important doctrines which are out there in the contract law. Though this particular litigation is from a Negotiable Instrument Act, and there are a number of judgments which are quite interesting. So hopefully, if you are dealing with uh, similar matters, or at least it will help you to learn about what this doctrine or what this principle is, and how time to time the same can be used, maybe even in your case. So the word vicarious or vicarious means act done for other. If you go to contract law, read contract law, there you have the contract agency contract or agency. And in principle, the agency is something, or the agent is always a person who is working for or on behalf of the principal. And what this vicarious liability talks about is the principal is always responsible for his or her agent. So let me give you an example. So let's say that you hire a contractor, maybe for renovation of your house, and that contractor again hires a subcontractor for the same. And in the process, the subcontractor does something uh, which causes financial loss to you. Now, in that case, when you file a suit or litigation, or maybe monetary suit for recovery of that money, for recovery of the amount caused from that damage, so you always sue the main contractor, the principal contractor, not the subcontractor, because the subcontractor is merely working there as an agent. Here also something similar happened. This person who used to be a director, in course of his role in a company, several checks were issued, and one of them got dishonored, and subsequently criminal case was filed, which mostly comes under 138 and 141. Section 138 specifically talks about dishonor of check or any other instrument for that matter. And most of the cases that come out of this Negotiable Instrument Act, they come out of 138 only, and 141 talks about offenses done by companies. And this appellant here was a director in a company when a certain check was issued, which was dishonored subsequently, and the respondent came to filing a criminal case against this appellant. Now, the reason why, as I was telling, that a principal is always responsible for his agent, or for his acts of his subordinates. Now, in a company, you have management. There are various roles, and directors are the one usually held liable whenever there is a dishonor of check. And this person also used to be a director, among many others. So that was the case. Now, this particular petition, the appellant used several judgments in their defense. And the first judgment which was used as his defense is this one: Kamalkishor Shrigopal Taparia versus India Ener-Gen Private Limited and such online SSC. And there is one other judgment that they use, SMC Pharmaceutical Limited versus such and such. Okay, there are three judgments actually. And what these judgments stipulated is that mere designation of a director does not create a vicarious liability. So, what it is saying that even though in a company directors are the one who are usually held liable for the actions of their subordinates, but uh, there are cases where uh, it is held that they are not the one who are responsible, and the reasoning there is that directors are mostly uh, working at the managerial level, and they are not the one who are engaged with day-to-day functioning of the companies. So as all of you know that in any company, uh, these financial aspects are also taken care by financial officers or other executives as well. It's not always the director who is directly in action. So these code says that just mere director is not enough to prosecute someone under vicarious liability. Some more elements have to be there. Now, the respondent used another judgment, which is Ashutosh Ashok Parasrampuriya, and another versus Gharrkul Industries Private Limited. And in this particular judgment, what Apex Court held is this, that the onus, the responsibility of proving that the director is not responsible for the act, directly or indirectly, remains with the director only. So the director has to prove, or director, it is the director's responsibility, because in general term the directors are responsible, which is a fact. But in case if there is a dispute and the director says otherwise, that I'm not responsible for, let's say, this particular division, or maybe for the finance matters. So this, because in every company or in companies there are many directors, or there could be at least many directors, or maybe there is one particular director for financial aspects, one director for some other aspects. So if situation is such, it is the director's responsibility to prove that it does not fall within his functional jurisdiction, let's say. And this is the judgment uh, uh, that the respondent used. Now there is one other judgment, National Small Industries Corporation Limited versus such and such, SSC. Now, in this particular case, what Supreme Court held, that non-executive and independent directors cannot be held liable under Section 138, read with Section 141 of the NI Act, unless specific allegations demonstrate that their direct involvement in the affairs of the company at the relevant time. So this is similar to this judgment, Ashutosh Kumar's judgment. Reason being, in Ashutosh Kumar judgment, the apex court held that the responsibility of proving that this director is not responsible for the act, or for, let's say, of uh, dishonor of the check. So this responsibility lies with the director himself or herself, but at the same time, a specific allegation has to be there against the director, proving that yes, he is involved in that particular uh, dispute, or at least it was under his dominion, or under his jurisdiction, or under his role, or under his function. So this just in one aspect, they're saying that the liability remains with the uh, or the responsibility or the onus of proving that the director is not uh, the right person, or director, the dispute is not within his dominion or within his role in that company. On the other hand, it says that specific allegation has to demonstrate that yes, this director is in fact responsible for dishonor of this check. So in that case only, the court can prosecute that director. But again, it is says that non-executive members cannot be held, because usually non-executive members and independent directors, their roles are very different rather than the regular directors, because it is the regular directors uh, who take this sort of decisions, or at least it could be within their domain, not the one who are non-executive, because they don't take the management decision. And this is another case where apex court clearly articulates that non-executive director plays a governance role. They are not involved in a daily operation or financial management of the company. So as I said, that in a company there are various departments. There are finance department, administrative department, so on and so forth, and different directors are responsible for a different role to play. Some might be taking uh, the finance aspect, some might be taking the management aspect, some might be looking into administrative, some might be for sales, and so on and so forth. So if it says that or sorry, since the non-executive directors often play governance role, and they do not engage in day-to-day affair of a company, they cannot be held with uh, affairs which are happening on a daily basis. And one such affair is this, which is issuance of check, or this monetary transaction. So there are many other judgments. I'm going to copy paste in the in the dialog box, so that if it is needed in your case, you can also use. So I hope that clarifies what vicarious liability is, and how this doctrine, or this principle, is used in NI Act. Thank you.